Thank you very much, and it's great to be here. Stephen, it's great to be here with you. It is a little bit comical to think of this as a fireside chat when it is very fiery outside. But to get things kicked off, why don't we introduce ourselves a little bit so that all of you know sort of the background for what brings us here today. And Stephen, do you want to start?
Yeah, sure. Thank you very much, Sarah. So my name's Stephen Roddy. I'm the global head of regulatory at blockchain.com. And I'll start by introducing blockchain briefly. We were founded in York, up in the north of England, not New York, way back in 2011. Our first product was a Bitcoin Explorer, where you could go on and sort of track transactions, check balances. We then quite quickly pivoted to become the very first Bitcoin wallet in the App Store back in 2012 or 13, I believe. And at one time sort of accounted for around 30% of the transactions taking place on the Bitcoin network. We've then, as many other crypto businesses have done, have sort of transitioned into sort of custodial, centralized exchange type services. One thing I think is quite interesting about us is that our sort of DNA and our roots are on the non-custodial side. We've moved into the custodial. A lot of the other businesses, the Coinbases, the Binances, the Krakens, etc., they've gone in the other direction. But we now operate a number of regulated businesses throughout the world. In the United States, we've got 35, 36 MTLs. In the UK, we're lucky enough to have recently received our money laundering regulation registration back in February. We operate out of the EU under a MiCAR license in Malta, and we've got a MAS authorization to act as a major payments business in Singapore. And finally, we're also quite active in Africa, having set up a digital asset exchange in Nigeria and also Ghana recently. One thing to note about us, unlike the sort of Coinbases, Krakens, Binances, we're not actually an exchange. We're a more typical broker, intermediary. When you place orders with us, we'll go out and check the market for it. But it's one differentiator of blockchain. And so that's a bit about me, and over to you, Sarah.
Awesome, thank you. Sarah Shtylman. I am a partner at Perkins Coie, soon to be Asher's Perkins Coie, and I've been in the crypto space. I want to say it was late 2013 that I was a very junior lawyer, and I first had a client, actually from a mutual friend of ours from blockchain.com, who said, "Hey, you should look at this Bitcoin thing." And at the time in the U.S., there was very little. FinCEN had issued guidance in 2013, but there was almost nothing else in terms of sort of the regulatory environment. But I was very curious about it for a whole bunch of personal reasons, and sort of my early career having launched during the 2008 financial crisis. And there was something really powerful about the idea of, like, you can be your own bank and it's this transparent record. But I'm a lawyer. So I started going to conferences and meetups and went down sort of the proverbial rabbit hole. Another thing about me is that when I went to law school, my goal was to become an in-house lawyer. And so this is what led me to become the second in-house lawyer hired at Coinbase in 2014. I built out their sort of money services regulatory program and got all of their MTLs. And if you had talked to me at the time, I would have told you I'm never touching a billable hour ever again. I've made it in-house. That's the dream. And then as the space started expanding, and at the time, candidly, Coinbase was not. I started feeling a little an itch professionally of, like, this is everything I thought I wanted it to be, but I'm kind of bored with what I'm personally doing. Like, there's only so many money transmitter license conversations you can have, and at the time it was a lot of explaining about Mt. Gox, and ultimately sort of had a mentor actually who encouraged me to think about it, but had this aha moment of, you want more projects, you want more variety of issues, like, that's what you get as outside counsel. So that is what led me to talk to Perkins Coie, and one of my partners, Dax Hansen, at the time, I was very transparent. I said, I'm not sure I want to do this. I thought in-house was the dream. I'm kind of surprising myself that we're having this conversation. And he said, well, we need help right now, and we have a lot of clients. So come give it a try, and if you don't like it, we'll place you with one of the clients. It's a win-win. And here I am almost 10 years later with the firm. So clearly that worked out, and I've continued to have a good time in the space. And a lot of where my practice has sort of grown up is obviously around crypto, but we've had a lot of crypto winters in that time frame, and lawyers need to bill hours and find work. And so a lot of what I also grew up doing is payments work. That was sort of the non-crypto or crypto adjacent piece. A lot of the same money transmission regulations, the same AML regulations, they apply to our big tech clients like Meta and TikTok and others, the same way if they're moving money around on their platform for platform monetization, that they also have to think about these same regulations. And so I ended up doing a lot of payments work in addition to crypto work, which has led to stable coins more recently, kind of really being a convergence on payments and on crypto. But with that,
I was going to ask if it's okay.
Yeah.
Given how long you've been in the space, Sarah, you must be one of the longest serving lawyers in crypto, at least in this room. It seems like there's a lot changing right now in the US, as some people have already alluded to. But I think it'd be helpful if we could just sort of deep dive a little bit into a couple of things. Firstly, with Genius, and then for a business like ours, and I think for a number of other players here, clarity is also going to be really impactful. So I'd be really keen to hear from you how things are changing at the moment in the US.
Yeah, it's not a secret, and it's been talked about on the stage already today that Genius is we're coming up on the 1 year mark since it was passed. Some of the interesting developments around that and around stablecoins in the US, we still are waiting for final rules. So the way Genius was drafted was that there would be 18 months for the various agencies who would have pieces of oversight to come up with rules that would sort of actually be the rollout. So now we're talking to a lot of the state trust companies or the money transmitters who are thinking about issuance, and they're like, how do we make this Genius ready? But even though it passed almost a year ago, we still don't have complete clarity even on how Genius will roll out. One of the interesting things that comes up, and this relates to the Clarity Act as well, is that the OCC in particular in their proposed rules have proposed what is arguably a stricter cap on yield than actually exists in the statute. They kind of framed it as, well, it's an anti-evasion provision, but they have basically drafted into their proposed rules, if you have any contract with anyone that purports to pay some kind of yield just for holding, that's actually designed to evade the statutory prohibition, and that's not allowed. And there's a lot of industry pushback. We'll see where that goes. But that's sort of the state of play. And then also on this, the state overlay. So in the US, we have federal and state, and that creates all sorts of fun issues. But if you are regulated by a state financial services regulator for issuing stable coins in the current environment, you will need to go effectively get a certification, a blessing from the OCC once Genius goes into effect. And there's still a pretty big open question of what will that look like, and will it actually just push everyone towards doing it at a federal level, because the rules will be so onerous and so different from what any state specifically would otherwise require. So
there's no kind of gold standard yet. You're still trying to figure out how it's going to work.
That's a good way to summarize. Yeah,
right.
Yeah. Up until now, or up until very recently, I would have said that actually the New York framework was kind of the gold standard and was kind of what the Genius Act was even based on. Things like reserves and audits and transparency and what you are and are not allowed to place in the reserves. But now we're starting to see proposed rules that are like, oh, this is new. So we'll see how that plays out.
And then shifting gears to clarity, I think there's a lot of debate around will it, or interest at least, will it pass, won't it pass? I would love to, I guess, firstly get your hot take on that. But then as thinking about it more practically from globally regulated businesses, what is it going to mean for us? Are we going to need to get a new license? When are we going to need to get a new license? And how is that potentially going to play out?
Yeah. Well, so my hot take on the will it, won't it, I would say it's set 50-50. I think on some level earlier in the year, I thought if we make it past February, it's dead. There have since been some conversations and some discussions and hearings that I followed that I have a little bit of optimism that it's not, clearly we're past February and it's not dead. But I think the window is closing. But more practically, assuming it passes, what does that mean? Fundamentally, I think it does two things. Clarity creates a statutory framework for token classification, which is very similar to sort of guidance we've received from joint guidance from the CFTC and SEC, actually just in March, where digital commodities are pretty clearly defined, and they exclude things that are digital securities, and they exclude stablecoins. And so that's sort of the number one framework. And taking from there, okay, now we have these new digital commodities. What does that mean from a regulatory perspective? There's sort of 3 new registrations and 1 new framework or designation. The new registrations are for being an exchange, a broker, or a dealer. And then the new designation is for being a qualified digital asset custodian. So that may or may not overlap with one of the registrations, or it may be some other framework, but similar to, for anyone who's familiar with existing qualified custodian standards for securities, it sort of creates a designation of what it takes to be a qualified custodian. And I'm trying to remember from there what the timing. So the timing of it, assuming clarity passes, there is in the current draft 180 days during which, if you are an exchange, a broker, or a dealer in your current business model, you will have 180 days to complete a provisional registration with the CFTC. The CFTC becomes the primary federal regulator of all of this digital asset activity. From the passage, there is also an 18-month period, similar to Genius, where the CFTC has time to write rules and regs as to sort of what the full registrations will look like. And it goes through similar to other jurisdictions, we go through a notice and comment period where proposed rules are put out there, industry and folks can weigh in, and then ultimately, sometimes there's further iteration, sometimes there's a revised proposed rule, and it goes through the same notice and comment period. That can drag out. But ultimately, once the rules are finalized on these 3 new registrations for being an exchange, a broker, or a dealer, then there will be a 180-day time period to complete the full registration as categorizing as one of those 3. And I think the other final point that is often a follow-up question for existing businesses, you can have one business that goes and obtains all 3 registrations. So sometimes some frameworks work such that you have to have a different entity conducting each of the different activities. As currently drafted under Clarity, you could go and get an exchange, a broker, and a dealer registration from the CFTC.
So something that all of the MiCAR practitioners in the room will remember, and I'm curious how this is going to work in the US, but with a bit of an anecdote to a former firm I used to work at, was 4 or 5 years ago, like, we operated one of the biggest exchanges, but exactly where that exchange was being operated from was like quite a moot point amongst different people in the organization. The tax people would have one view, the regulatory lawyers would have another view, like the product guys would have a different view. And like, candidly, what we would say to different regulators wouldn't necessarily always match up. But what MiCAR did is it forced people to take a view on these kind of questions. Like, if you're going to get authorized in the EU, are you going to be authorized as an operating crypto asset trading platform, or are you just going to do these kind of intermediary activities? And it sort of forced businesses to decide, all right, I'm going to put my exchange in Ireland or wherever, and so it's going to be supervised by the Central Bank of Ireland. And the reason that the European regulators did that was because they didn't want these big offshore exchanges to continue to operate largely offshore and have like a rump kind of shop front brokerage business in the EU that they get to regulate, but really fundamentally everything else is offshore. So MiCAR did that, and a bunch of businesses have sort of forced and established themselves in the EU. We've got, just coming down the line in the UK, a similar question. The FCA is clearly wanting to regulate exchange businesses, and they're kind of forcing the bigger exchange groups to set up a branch here, or they're making it quite difficult for them to not get regulators in exchange. And my curiosity is, like, having just gone through this quite nightmarish, how do we figure out the trading flows for businesses that have fundamentally spawned themselves as global entities taking clients from anywhere? We've now kind of like segregated these things into different jurisdictions in the EU, the UK, and now the US is coming down the line. Are some of these businesses, do you think, gonna have to reverse engineer some of this? Like, is there gonna be some kind of, I don't know, like kind of equivalence concepts in the US, or or is the CFTC going to be happy regulating, like, let's say, a US broker trading on an Irish exchange, for example?
Yeah, I think the short answer is that it remains to be seen. I don't have a clear view of a crystal ball of where we're headed. What I can say is in the Clarity Act as proposed right now, there's a designation for being a comparably regulated institution overseas, and there's sort of a 2-year period that is contemplated for the CFTC to come up with further rules around what it would take to be comparably regulated outside of the U.S., such that you wouldn't need to be regulated in the U.S. As currently drafted, it doesn't actually mandate that the staff of the CFTC has to designate any foreign operating exchanges that would be able to kind of fit in this exemption. It basically punts it to the CFTC and says, you have 2 years to figure this out. And if you figure out a way that, that sort of solves this cross-jurisdictional problem, then great. And it's similar, I think, in contemplation to what the U.S. currently has under the CFTC with a foreign board of trade. It's sort of this notion of like, okay, the CFTC sort of has a framework for doing this. If you want to apply this to digital assets, great, we'll let you do that, is kind of what the statute does. Again, with no crystal ball, where does that leave us with a 2-year clock and rulemaking required? I think it partly depends on how quickly Clarity passes, assuming it does. And then from there, how quickly the current administration can get through the proposed rulemaking process. I think we have a relatively crypto-friendly, want to support and open up business administration right now. And if that continues and or if a lot gets done in the next couple of years, then I think there will be a path for foreign exchanges to just simply be able to register pursuant to this exemption.
So best case scenario seems like we're going to be looking at getting a license sometime late 2027 or 2028.
Seems
which is
so.
Interesting, because we've just done MiCAR, now we're going to have to do the UK thing, and then immediately have to go and do the US equivalent. So, and then what do you think is the sort of worst case? Like, what happens if Clarity doesn't pass? How can businesses like blockchain prepare themselves for that?
Yeah, in some ways, it's sort of status quo, which the status quo in the U.S. is that most exchanges operate through state money transmitter licenses, to a lesser extent through state trust companies. The reason that is to a lesser extent is because operating a state trust company is kind of an order of magnitude more difficult than operating a trust company, and it does not give you nationwide coverage. One thing that we're already seeing as a shift, though, that I think will continue is that the OCC will charter national trust banks, and more crypto-native firms will look to operate per a national trust bank, which does preempt all of the kind of state patchwork. And so we're likely to see more and more firms go for the OCC chartered trust bank. Beyond that, I think we will continue to see rulemaking and guidance. We've already seen this not only from the OCC, but the CFTC and the SEC, and publication of no action letters. And that will create, I think, in the short term, a clear framework of if you want to operate, here's the framework that the current agencies think is okay. Another fascinating kind of broader atmospheric thing in the US, though, is that just a couple of years ago, we had a Supreme Court case called Loper-Bright, and it got rid of something called Chevron deference. What Chevron deference was from a far older Supreme Court case that effectively said, if an agency issues guidance or issues a no action letter, then courts would give deference to what the agency said they thought the rules were supposed to mean. No longer is that the case. And it's interesting because when Loper-Bright first ruling came out, the crypto industry loved it because we had Gensler and the SEC, and everyone was sort of like, oh, great, we no longer have to give as much weight to what Gensler says. We're now in a scenario where if Clarity doesn't pass, we may come to wish that agency guidance had a bit more. And I think the final thing I will say about that, though, is I don't think we're going back to a Gensler world, regardless of administration change. I think the amount of institutional buy-in from banks and other kind of more serious financial institutions, it's sort of like the ship has sailed on whether or not TradFi wants to be in on crypto on some level. So I don't think we'll ever go back to sort of a ban or regulate by enforcement type of feeling. But I also, and I think the other reason for that too is just political spending, campaign spending. Enough people, whether individuals or institutions, will back candidates that are not anti-crypto.
Yeah, it's been quite incredible to watch from this side of the Atlantic how much things have shifted in the last 12 months.
Yeah. Well, and I feel like I've been doing a lot of talking about the U.S. landscape. I would love to hear a little bit more about what you are seeing, kind of more atmospherically on these same points, and then also how that plays into blockchains specifically and strategies.
So, like, just again on that atmospheric point, for quite a few years, obviously, crypto businesses, at least as long as I've been in the space, which is since 2022, were kind of hesitant to invest in their US operations because they didn't have clarity around what was coming next and how things were going to be regulated, or even if like their activities were going to be legal. And so there was a huge shift to like invest in the UK, invest in Europe, and really double down in those jurisdictions where even if the laws were kind of tough, people felt like they could figure it out and they knew that they could comply. What I've seen like really clearly is just with the guidance that's been issued jointly by the SEC and the CFTC, the various sort of no action letters that have come out, whether it's sort of the phantom stuff, which is like, to me, like an incredible thing, basically allowing phantom DeFi wallet, non-custodial wallet to connect to regulated exchanges in the US and take a commission or transaction-based commission, basically operate like a broker. That's like an incredible shift of thinking. And then the stuff on prediction markets, it just seems like there's a real vibrancy in the US and like the shift is kind of like swung back. So the pendulum has shifted, and that's been quite interesting to watch. On the other side, in the UK, it does feel like we're in very much a sort of consumer protection mode. And I would really love it if we could sort of maybe take off some of those shackles a little bit and allow a bit more innovation and risk. I was at a meeting with some US lawyers a couple of weeks ago, and I flagged how like various different products are banned in the UK, whether it's sort of for retail, perps, prediction markets generally. And the comment that was made was, well, you need retail in these innovative products because they're the people who are going to take risk. No big bank or like trading desk is going to get into these products because there's so many steps when they're in their infancy, so many steps they have to take before they're able to trade. On the specifics of things, Sarah, in Europe, MiCAR fully comes into force on the 1st of July, which is next week. Or I shouldn't say fully comes into force. The grandfathering period ends. And so for those businesses that have taken advantage of the longest possible grandfathering period, which is 18 months, their ability to operate ceases next week, basically. ESMA put out a statement yesterday calling firms' attention to that, and they noted that like some significant operators haven't got their license yet, and that's obviously a pretty clear like
some who won't be named.
Some who won't be named, or maybe will be named. I guess Binance is the one that hasn't got a license yet, and so it'll be really interesting to see what happens there. They specifically called out how they expect firms to wind down, which is immediately ceasing things like buy and other kind of like generative products, only allowing sell and withdraw, and that custody can only continue for so long as is necessary to effect an orderly wind down. So it'll be super interesting to see what happens there. And then, like, surprisingly, or maybe not surprisingly, we're already into a phase 2 of looking at MiCAR. So there was an ESMA consultation or commission consultation that came out a couple of weeks ago, looking at a few different points, and like some of it is maybe a little bit more sort of boring or dry, like the stuff around how CASPs are being regulated. There are 3 areas that I thought were interesting on a cross-border basis. The first one was they're specifically looking at DeFi because there's a carve-out in MiCAR for things that are fully decentralized without ever going on to define what that actually means. and they've given us a bunch of questions in their consultation around what might be indicators that something is not fully decentralized, and it's things like a person or individual that has the existence of an identifiable intermediary, whether a person or a group of people have a high degree of control, whether there is marketing of a DeFi protocol by an identifiable group of people, which I think is interesting because all these DeFi protocols are marketed by somebody. And so I think
to some extent, that's Ethereum even, right?
Yeah, right.
Could argue at least.
So when I read that, I think, okay, basically they're coming to the conclusion that nothing's really decentralized, maybe other than Bitcoin, perhaps. But helpfully, they've also, they're not saying, right, therefore you're regulated. They're proposing or seeming to propose like a certification scheme. And so say for DeFi protocols that don't meet the fully decentralized test, could we propose a certification scheme, and would that be a public issuance or potentially a private body? Should DeFi protocols have to embed specific compliance controls within them? So I know that there's been like a pretty big debate in the US around what it means to be fully decentralized, and I think it's interesting that that's coming out now in the EU. I've also got to give a shout out to the Maltese regulator as well, who have also put out something on this. I think they're kind of interesting because they were the first in the EU to regulate crypto back in 2018. So they're a bit of a bellwether, I think, in terms of how these things can be thought of. And even though they're part of the EU, they sometimes have been sort of taking quite particular positions on things. And because so many of the big exchanges are regulated in Malta, they've got some pretty good expertise around these quite tricky issues. What were the other things? Issuance of dual issuance of stablecoins. Obviously, one very major stablecoin wasn't authorized in the EU, and the other one was. And the way that Circle has been able to operate is, through their French AMF licensed EMI issuer, but through what they call like a multi-issuance model, where I think a lot of the either sort of historic tokens which were issued prior to getting a MiCAR license or EMI license are basically grandfathered in. And the idea is that you kind of like, it's almost like a soft equivalence where European regulators know that they're regulated elsewhere, and even though that this token was issued by this person, this was issued by the other, they're fully fungible. The EBA had some concerns about that from prudential perspective, which I can totally understand. But I think that the conclusion that the market reached was entirely pragmatic. You can't have a situation where you have like EU consumers essentially locked out of global stablecoins. And so it seems like they are, well, actually they're specifically saying, look, MiCAR doesn't prohibit this. And they're asking for comment and feedback and how that can work going forward. The final thing is interest payments.
I was going to ask, how does that play out here?
So that's interesting. That like at the moment it's banned in MiCAR, and there's in this latest consultation, I think there's only 2 questions. It's kind of like, do you think we should allow interest payments? And
is it banned specifically to the issuer, or does it extend beyond?
It extends beyond,
okay.
And so CASPs can't pay, like CASP, like a local brokerage or exchange, can't pay
on any stablecoin, regardless of issuer. Okay.
And I wonder if that's the reason they're looking at it is because some of the big banking groups are getting together and looking at doing their own stablecoin, and maybe they realize that they need to compete. So those are the key EU issues. In the UK, as everybody here, well, maybe not everybody, but a lot of people here will know, we're finally getting into a pretty deep licensing process. There were some comments earlier around like the lift it's going to be. I think that's absolutely right. It's going to be a huge lift for crypto firms, even the most sophisticated ones. Things like coming into the senior managers regime, the sort of prudential regime, market abuse. It's going to be a meaningful shift. But I think that's okay. In some respects, I'd love an easy ride, but like we've got to remember that the way that FCA is doing this is that they're bringing crypto into the existing financial services regime. So once you've got like a Part 4A license in the UK for doing crypto, you can just add different asset classes and stuff to your permission. So you can do futures, you can do CFDs, you can do options. So you're being treated like a traditional broker. And so I think, with that, you've got to accept that there's going to be a pretty big lift, and the responsibilities are going to be pretty pretty meaningful. I'm conscious we haven't got a whole lot of time left, 3 minutes, so I don't know if you've got any last.
I did have one last question, which is, going back to blockchain.com having roots on the non-custodial side. Curious what you think for DeFi and non-custodial solutions. What should that regulation look like?
So my sort of view on that is that there should be some kind of safe harbor. Like I would have loved to have seen the UK. They've actually put out some quite unhelpful guidance on what it means to be a non-custodial wallet. They say basically if you connect to a protocol, so if you connect and enable orders to be executed, if there's an identifiable person behind that, then you might be arranging deals and investments, which is an incredibly broad UK activity. I would love something like if you meet certain criteria, maybe you build maybe there is some kind of a certification regime. Maybe there is, we talked earlier about the risks of DeFi, maybe there is some kind of a warning, etc. But then if you've done that, you've established yourself in the UK, then you've basically got a safe harbor from being regulated under FSMA or anything else. And I think it would be awesome if we could actually incentivize people to come in and set up in this jurisdiction. And I think that firms would be okay with that. And that's kind of my instinct, but I don't know. Do you have a view?
No, well, do you have another 30 minutes? I don't have a strong view. I think probably something similar to a certification. I also think, and this was talked about in some of the earlier sessions, take a step back and ask, what are we trying to regulate here? What is the potential harm? And I think with that framing in mind, it's hard to sort of use existing financial services infrastructure to apply in some of these cases. So whether it's a non-custodial wallet, it's do you need the right disclosures around how this technology might fail you or what it might mean to lose your keys? And that's different from the types of disclosures you might need if you are, a Uniswap or you're operating some kind of DEX. And so I don't have a strong view. I also think some of the AML concerns are real, and our existing regulators aren't going to stop thinking about them. But that's an area where I think if given more time, I think we will see blockchain-based identity take leaps and bounds in a way that may help solve at a technology level some of the AML concerns that currently are really hard for more traditional financial firms to solve. So no strong views, but lots of thoughts about how we might think about it evolving. But wanted to leave a tiny bit of time. I think that's probably where you were going. Do we have any questions? Everyone wants lunch.
Cool.
All right. Well, thank you all for the time. Appreciate being here.